the Supreme Court has ruled that a Louisiana abortion law is unconstitutional and needs to be abolished. The law required that abortion doctors have admitting rights to nearby hospitals. Now, those in favor of this law basically argued that this is a matter of medical safety, and those opposed to it felt that it was an unreasonable expectation and that it would limit the number of doctors who are able to provide abortions in that state. So we want to bring in Ilya Shapiro. Ilya, you are with the Robert A. Levy Center for Constitutional, and all my eyes are all over the place, so excuse me, for Constitutional Studies. There you go. All right, so Ilya, give us the basics. How did the Supreme Court decide? What's the split? And what were sort of the arguments on either side?
Right. So this was, as you described, certain regulations in Louisiana about requiring admitting privileges and being close enough to a hospital, which essentially closed down, I think, all but one clinic in Louisiana. The majority, meaning the four more liberal justices, had a detailed 40-page opinion about how these regulations deny access to abortion and violate that constitutional right. John Roberts, the Chief Justice, joined only in the judgment. That is, he said that as 5 years ago in a similar case out of Texas, he disagrees that this violates the right to abortion. But because of the doctrine of stare decisis, that is, we don't want to overturn precedent unnecessarily, he will agree to strike down this Louisiana law. So purely on this doctrine of keeping in place five-year-old precedent, that's all that he wrote about. And then the four other conservatives dissented for various reasons that I haven't gotten into yet, but each of them wrote separately.
So it's interesting, Ilya, that the Chief Justice said respect for precedent compelled him to vote with the majority. Can you explain that to our viewers?
Right. So there's this doctrine, it's Latin. Stare decisis means let the decision stand. And it's the idea, it's not something that's in the Constitution or some other, written statute. It's the idea that we want stability in the law, and people need to be able to rely on legal rules being fairly unchanged day to day so they can plan their personal or business lives. And so sometimes it's more disruptive to society to correct an erroneous decision than to let that error stay in place. And so whenever you have important decisions, Citizens United, a labor worker speech case called Janus a few years ago, property rights cases, this comes up. There's always fights about how egregious the previous decision was, how many reliance interests there were, that sort of thing. And so here, John Roberts says, again, I disagree with the liberals, with the four liberals, that Louisiana's law is somehow violates the right to abortion, even as described in Planned Parenthood versus Casey. But because of that five-year-old precedent, I will not disturb it, given that it's essentially, he's saying, the same case.
So we had been for a while now talking to Kate Smith, who's been doing, all sorts of coverage on abortion across the country. And, she has talked to us a lot about laws like this that don't out and out make abortion, don't outlaw abortion, but tighten, sort of put the screws to abortion clinics and make it a lot harder for them to do business. When you talk about the Supreme Court Justice's decision, to me it seems a little weak, like there's wiggle room here, like we could actually see this come up again.
Well, that's because the standard that we're working under, Planned Parenthood versus Casey, recall Roe versus Wade is not the governing law on abortion. Roe versus Wade set out a trimester rubric, and with each trimester, there's different things that government can and cannot do, basically. Planned Parenthood versus Casey in 1992 changed that to a general undue burden standard past the point of viability. So as technology changes, restrictions can come in at different points in the pregnancy. But what is an undue burden? For a long time, while Anthony Kennedy was on the court, the joke was it's whatever gives Justice Kennedy a headache. And really, it's hard. It's not a clear rule of law, and it's very subjective about what constitutes a so-called undue burden on the right to abortion. So even without overturning Planned Parenthood versus Casey or Roe v. Wade, there is wiggle room for justices to decide, well, this kind of restriction is not an undue burden. It's just, a normal restriction. In this case, Texas argued, or Louisiana argued, as Texas did 5 years ago, that this was for the health and safety of the patients and the child. That if you don't have a hospital close enough or a physician performing the abortion with admitting privileges, that is too dangerous. And so, just like you can regulate clinics, abortion clinics in all sorts of ways, this is another one of these health and safety regulations. Now, the majority today, like it did 5 years ago, disagreed with that. But interestingly, Chief Justice Roberts was in dissent 5 years ago, and here, at least in the ultimate judgment, he's with the majority in striking down the Louisiana law.
Ilya, I know it's hard to sort of put this in context in terms of political ideology and leanings, but now Justice Roberts has sided with the more liberal justices on the court in 3 recent cases, including this one. You had the LGBTQ decision, and so I wonder, I know that there's been some analysis that's been done on justices who are sometimes conservative when they are judges before they are then nominated to the court, who sort of drift to the left. We're talking about Justice Kennedy, Justice Breyer. Are we seeing that with Roberts at all, or is there something else here at foot?
I don't think this is a situation like Justice Stevens or Justice Souter that were, stealth candidates or thought to be good conservatives or Republicans and moved left. I don't think this is an Anthony Kennedy situation either, where it's just a kind of a moderate or a squish, as some people might say. I think John Roberts is trying to be strategic, and he is more dedicated to judicial minimalism, restraint, much more than originalism or textualism or conservatism or what have you. I mean, I don't think that he's moved left or evolving or, all these aspersions that have been cast on past justices appointed by Republican presidents. Instead, his whole project is to have the court step with as small steps as possible. That's called minimalism or incrementalism, and also to try to remove the court from the political discussion as much as possible. I'll let you be the judge of whether he succeeded in depoliticizing the perception of the court. My personal view is that when you take these non-legal considerations into account, you're only hurting the perception or the legitimacy of the court. We can agree or disagree on somebody's interpretive theory, but if you're playing strategy, you're kind of as in some cases, both the left and the right have called this being a junior varsity politician on the bench. That's not as well regarded. But anyway, in all of these decisions, you mentioned the employment discrimination for sexual orientation, gender identity, the DACA case, and now this one. He is not agreeing with kind of the liberal progressive view of the Constitution or of statutory interpretation or what have you. He is making these very technical procedural arguments to try to not have bold rulings one way or another.
Ilya Shapiro, always great talking to you. I feel really lucky that we can kind of grab you at a moment's notice and you can give us all this insight. So thank you so much.
Well, it's easier when everyone has their home TV studio ready to go.
It's true. It's true. Thanks a lot.